the first to know Nsem-Pii TV.
Enra was one of the busiest days for former Attorney General Godfrey Yeboah-Dame. Enra na also representing NPP Ashanti Regional Chairman Bernard Nsem-Pii, Chairman Wuntumi ewo CID headquarters. At the same time, now the embattled Chief Justice, the suspended Chief Justice, Her Lady Chief Justice Torkonoo, and so ewo in front of the 5-member committee of inquiry ya omu probe into various petitions yigina so they establish a prima facie case diti ano eno so na His Excellency John Mahama ejina so they are suspended no enti enro na a very very busy day for the learned Godfrey Yeboah-Dame. In fact, Chairman Wuntumi de odikugui bra na CID a press 3 charges at the etiano say or mining our forest reserve or destroy our water bodies or engage in illegal mining. All these 3 charges, not a single evidence. And a criminal investigation department of the Ghana Police Service, it me presented the support to claim. Until was a granted Chairman Wuntumi a bail of 5 million Ghana cedis with 2 sureties. Now aside any HRMO or CID as you later in the week. At the same time, said the Mr. American. Now the embattled Chief Justice and so AFAC, Justice Gabriel Palmer, Justice Asiedu Adibu, Daniel Yaudumelovo, any 2 others the committee hearing. Committee need to one or more petitioners and after or more witnesses. Yes, say or more kikan or more someone and document a free the Supreme Court of the land bar at the command the committee members. A supplementary affidavit in support of motion interlocutory injunction. The embattled Chief Justice, Her Ladyship Justice Torkonoo, a file with the Supreme Court led by the learned Attorney General Godfrey Yeboah-Dame. Now, this supplementary affidavit, in some way, and Nsem Ketwa. To me, lawyer Chachuchi Kata, lawyer Tsatsu Sory, representing 2 of the petitioners. In fact, they were in ultimate shock. There was now more more witnesses, petitioners' witnesses, and this supplementary affidavit, free Supreme Court, a Bobura committee no asye. Now, anyway, supplementary affidavit so the plaintiff or the applicant, Her Ladyship Justice Gertrude Araba Isaba Saki Torkonoo. The defendant, as usual, the Attorney General Dominic Ayini, Justice Gabriel Scott Palmer, committee chair, Justice Samuel Kwame Adibu Asiedu, or committee member, Daniel Yaudumelovo, former Auditor General, committee member, Major Flora Bazenura Dalugu, and Professor James Sifazisa. Now, we share say statement of claim. Say or no Gertrude Araba Isaba Torkonoo, Justice, or a citizen of Ghana, or a Chief Justice of the Republic of Ghana. Now, or Akwenya say obey dipusu an affidavit on matters within the knowledge, the information, and the belief. Now, which on the 21st day of May 2025, we institute 2 instant action for reliefs endorsed on the rate of sermons. On that same day, Osa filed an application for interlocutory injunction seeking for reliefs stated on that motion paper. Now, Enadia respectfully seeking leave of the Honorable Court to bring to the court's attention various developments since the filing of the interlocutory application injunction, which evidence a complete discretion of no Gertrude Araba Isaba Saki Torkonoo the basic constitutional right to a fair trial, violation of the dignity and subjection of her to inhuman and degrading treatment from the committee. In fact, she is being meted out to accused persons on trial for treason and other offenses against the state. Say the new mayor Kosono, Sanu Huno. Now, one, or say that I was informed by my lawyer, Kwabena Edu Kusi Esquire, say the proceedings of the committee set up by the president to inquire into the 3 petitions filed against me had been adjourned to a day after the commencement of our action in the Honorable Court, that is to the 22nd of May 2025. 2. That on the 22nd of May 2025, I appeared before the committee together with my lawyers and informed the committee members of the suit I had instituted against the Attorney General and the committee members, in response to which the committee requested to receive copies of the processes filed and adjourned proceedings to the following day, Friday, the 23rd of May 2025. 7. That on the 23rd of May 2025, notwithstanding receipt of the processes filed in the Supreme Court, including the application for interlocutory injunction, the members of the committee indicated their resolve to proceed with the conduct of the inquiry. Chief Justice Gertrude Torkonoo na echirim say, Okwa file interlocutory injunction crown suit ewo Supreme Court. Now, what furnish the committee members and the Attorney General with copies of enema okwa file ni nyina. Still, committee na yo wadwene say on betrase. Ya che say emremu no entiase nim, because interlocutory injunction now file here no. The Attorney General is the first respondent. All 5 committee members are respondents. Yeah, or seek various claims. Together, this same committee assigned to me court transfer say, yeah, twaswa probi nipa wa file an interlocutory injunction at the highest apex court of the land, that is the Supreme Court, ADTI. 8. That this was so, even though I have to date not been told the basis for the determination of a prima facie case against me, and the specific allegations in respect of which a prima facie case has been established for me to answer, to enable me and my lawyers our legal rights to adequately prepare a defense to the charges against me. Sadie we kwa na metia na ye mabufu kra. 1. Musema establish a prima facie case the tie depa enuntima suspended. Upon the suspension, Musema te committee of 5 members ya omo eme probe into 1. Petition say etwedi no. 2. The established prima facie case no be yano. Meanwhile, enipa no amomo probe no amu demanding answers dey free the hono. The grounds on which amu establish a prima facie case mon kan kire no. Petition se krono amu gina so dey establish a prima facie case mon kan kire. Enti musi mu probe no na mu enkwai no musi omra na omayi dia no. Enti omra committee no ani mansa na maka kire ne say petition we establish a prima facie case wo di tia wonti yewa no ana. Ebra nipa no ntumi prepare adequately for the issues raised against her. Is this fair trial? We are fair trial. Momosoma establish a prima facie case on certain petition the tia na intima suspended. Petition say dia he na mu gina so dey establish a prima facie case di tia no. Mon kan kire nipa na won prepare na won tumi emma mo the adequate responses to those petitions on which you establish prima facie case. Mosiyan kan kire. Wo dia wa bra na be yi wan. O meyi na no on what? Ti eno na Chief Justice Eka Ehon Asem. Next, or say that on the previous adjourned date of the committee sitting of 15th May 2025, at which I was represented by my counsel. The committee refused to recognize my counsel because I was not personally present and proceeded to fix subsequent hearing date and make arrangements for the hearing without involving my counsel, even though he was present. The committee, shockingly, simply refused to recognize the same counsel on whom it had served a hearing notice only a day before. Etiaha, Chief Justice get to Torkonoo Chirima. Joining committee sitting the call 15th May. Bibi nti want to me ama, but emremu no se want to me ama ne counsel ye ne lawyer ni ebetumi a represent him. Ne lawyer ni ko represent no na committee for no entoa setting no so a. Omo say ono Chief Justice get to Torkonoo enye present na ne counsel na ne lawyer ni representing na abenti no omo ntumi ntoa meeting so. Meanwhile, na adia bechia mo ma ye meeting no kra no a day before and omo frɛ no inform no. Ti adia bechia mo ma trase kra no omo frɛ no inform no. Ya na kyese on prepare na nyoma bebrebe nanim. Enu nti no instruct the lead counsel say, "Kona kwaku gina manem because you are my lawyer." But still the committee insisted say per arrangement e was say no Chief Justice wo personally. Na say nipa no yare no the hospital. Enunti committee no postpone the hearing. Ya omu chiremu a even with the hearing no she cannot involve her counsel. Ontumi fa ne lawyer ni ma. Even though throughout the counsel has been present. The Chief Justice Descarbone said, shocking, very, very shocking why the committee is refusing to recognize this same counselor. And serve the committee members with the interlocutory injunction from the Supreme Court. Very, very, very shocking. Say Ghana, you to me deal with a citizen. Say yam penemanelo ye ni nka ho ma. Meanwhile, it is a committee of inquiry probing into issues. Very, very shocking. The next one, Chief Justice say that the committee on the 23rd of May 2025, contrary to known rules regulating proceedings of committees or commissions of inquiry, indicated that the petitioners shall not give evidence themselves, but shall be calling other witnesses to give evidence to support their petition. Wo na wo akọ transfer petition die tie will be say the panu we na waye into president gina so na for unity na drubra ayate committee si enye hwehwemu wo petition mu a wo watwere dia ba ye gina so dia suspend the panu a o se mimi ntumi media dance o me am petition am twere ye ho na o me fra obi fra bontemum e na be dia dance on the petition I personally wrote seeking for the removal of an individual. Who does that? Or what laws or rules governs this? If we are to be fair to ourselves and not be engulfed in propagandous political insinuations, who does this? Say me mitihui. My petition e dia frɛ sister Araba ho. My petition dia frɛ sister Araba ho. Say sister Araba ye we, sister Araba ye we, sister Araba ye we. Enti yentu ni mfiri bifie. The drobra fie wura apani pa ka no ho. No mo se yemra ne yemetie ensɛm a memetwere di frɛ sister Araba no hwɛ. Say docracy nyina so fa ntunu free fia me a me metwere nsem de fa sister Araba ho se ntunu fa free fia be se me ntumi ma ma evidence of nyoma metwere ye ho na emomu no me kwa akofa obi a ne fie ben me e na abedi adanse ye sampan se ma metwere de fa sister Araba ho na no krantie ntu sister Araba fa free fia asemu etoso if not that a certain group of people have a parochial interest in come what may, the Chief Justice must be removed. Then she went on to say that this is completely offensive to known rules of procedures regulating the work of committees or commissions of inquiry, as the so-called petitioners or complainants, when they formally appear before the committee or commission of inquiry, are mere witnesses whose evidence will have to be taken and cross-examined on oath by the person affected by the proceedings. As simple as that. Committee and now commission of inquiry no mu dwumadi ni say wo no awakotena se atwere petition diafo bi hu say we nipa no waye sei ni sei enti yenyi ni mfamfiri ho no oba na wabeka ntam se nsem a metwere ye no mia na medi ho adanse eye no kore nipa no waye we sa na ye no na wo so kofre witness free baabi aba ama na baba ba di adanse dia fa wo nsem a wo twere wo ho no e de ntam no no ka. What oath is that witness supposed to take on your behalf to defend you petitioner, to defend your petition that is seeking for the removal of the affected person? The Chief Justice Chiremua emra bia ni honomu a in a committee or commission of inquiry emma kwan say obi momu meye a witness in place of the petitioner himself, because the petitioner himself should be the witness to what he wrote as a petition, not someone. And the Chief Justice made it clear, said there are no rules of procedure that govern the ECOSWAN. That other developments, like the denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephones and laptops for myself and my lawyers, even though counsel for petitioners have access to their phones and laptops, and the conduct of the hearing itself in a high security zone at the premises of the Osu Castle show a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental human right. The question I rehuan kasa na it is only in Ghana na sanyo mebekoso. What suspending the pan? What raising charges from written petitions at the TNIPA? Ose what the committee of inquiry emprobu nipa. Wa yesuti waba one. E di enti na wo hold committee meeting e high security zone. Sabe ya ma me get through Torkonoo. Wa committee war crime against humanity. That is the number one. What e di poti na waye. Watu wabanya to ogu. Even those coup plotters ni adi senior ye wom coup plotters ni adi na edu omo asem wo court senior ye wo. Two, the ire ne ma mo se mo nsi meeting no ase. Fair enough. Laptop ne phone so a ono ene ne counsel e de aba ho a bibia ni obetumi make reference to no mo se mo nyusu bi ho ade abufu ni say petitioners no lawyers omo represent omo ne de lawyer Tsatsu kata lawyer Tadio Sory ne de. They have free access to their phones and laptops. But nipa no be different in the only access to the phone and the laptop. The phone and the laptop have been seized. Now also body search searching search criminal. Ha, why? A dear pa near me Gertrude Arabes about Torkonoo why? To subject her to mental torture, as she's put it. Because you are subjecting her to mental torture. Usukasta. Why was Usukas? Or someone say you are violating her fundamental human right because a committee no aduma warrior, which is onyan who couldn't chat. Onyan no no diakasa. She doesn't have right to anything. The committee ni pebia no moyen. Why? And was that Beyonce that all Article 146 proceedings, with the exception of the one I am being subjected to, had hitherto been laid in a judicial facility, especially the court's complex. The location of proceedings affecting me to a condoned high security facility boggles the mind. So can Article 146 proceedings of committee of inquiry and commission of inquiries except on no die nyina kwaso wo judicial facilities court complexes edi enti ono kwa de na kwose osu casta odwene ho awonte ase okenka article 146 of the proceedings of committee of inquiry and commission of inquiry. It clearly stipulates where those meetings should be held. What is the exception about onuntia court bebrebe wo Ghana yenya baby amfa na nkose osu casta? What is so unique? What is so special about the case? Ye don't know everything about what is going on within the petition. It looks as if we say entirely different from what is stipulated within our laws. No, but say because what is actually going on? And I was saying that I respectfully pray for this honorable court's intervention by the grant of an injunction to prevent the assault on judicial independence and protect the security of tenure of the Chief Justice and justices of the Superior Court of Judicature at play in the instant case. Wherefore, I swear to this supplementary affidavit in support. Sworn at Accra this day of May 26, 2025. Tinaye Enra Enyumbre, Commissioner of Oaths, the Registrar Supreme Court Accra, and to the above named respondent. Way the supplementary affidavit Justice Gertrude Araba Esaba Saki Torkonoo Enra Enyumbre of file ya chese munsem no mu do ye papa. E mu do so we are well-thinking Ghanaian, we are well-meaning Ghanaian. Just throw away the political lenses. For nine, put your legs into the muck, not the shoe, into the muck of your Mama Justice Gertrude Torkonoo. For the sao mame no. Any other fasa nyuma how would you feel? Let's not be clouded by political lenses. Nobody has stopped the Commission of Inquiry from probing into various petitions leveled against the Chief Justice. Obian can say committee need to mean Nejuma. But the committee Nejuma DM, at least let's show some maximum respect to our Chief Justice. Now or no so anu year or and for all these petitions and then let's compare and contrast as we have learned and respected justices of the Supreme Court sitting on this committee. Now, the outcome of it, any outcome, Ghana ni biya tia. If I don't say, in fact, pepe yo aye juma in this particular case.